Hi, Doctor. We are from Section 1 from Group Topic Number 10. The title is Issue Pertaining the Lease and Tenancy in Malaysia. We have 6 group members, which is me, Yonglun, Chiwi, Huishi, Pang, Vinkian, and Pei Wen. Now, let us start our presentation with the introduction.
Alright, I will start to present our introduction for the issue pertaining lease and tenancy in our report. First, the definition lease. Lease is referred to as registered lease or sublease for alienated land under Section 5 of the National Land Code 1965, also called the NLC. For other side, a lease is a building contract between the licensor and the licensee. In accordance with Section 221(1) of the NLC 1965, the licensor may grant a lease that covers all or a portion of the land. Another condition that must be met is that a lease duration must exceed 3 years as required by Section 221(2). Otherwise, the tenancy will be considered. Second, the definition for the tenancy. A tenancy agreement, which is a legal contract between the tenant and the landlord, detail the party respective legal right and obligations. Tenancy should be valid when communicated orally or in writing, and if the tenancy is established in writing, the document cannot be registered. A tenancy or subtenancy is defined as any tenancy or subtenancy that is granted for a term not exceeding 3 years and referred as tenancy free for registrations. Besides that, for our finding in report, a short note about the tenancy agreement is don't have any standard forms, but they often include in agreements for the tenancy. For example, have the for information about the landlord and the tenants, that defining the start and end of the predetermined rental terms, and other else. So this is very important, are often included in the tenancy agreements. So for this slide, we will present the discussion in 5 case review supported by Ed. First case, Rohasa Sdn Bhd versus Weatherford Sdn Bhd and Arno. Second case, Yong Hong Tiong versus Xiu So-hwa and others. Case 3, Wee Tiang Yap versus Chang Chang Brothers. Case 4, Metramite Corporation Sdn Bhd versus Fazen Holding Sdn Bhd. Last, case 5, Wan Shamila Wan Jafar versus Mahmo of Ma. So these 5 cases will be discussion and presenting after this slide.
Hi, Doctor. I will present about the case review 1, Roha SS Sdn Bhd versus Weatherford M Sdn Bhd and Arno in 2019. The tenancy between the Roha SS Sdn Bhd with the Weatherford M Sdn Bhd and Arno has since expired. Since January 2009, the both parties start negotiating for a new tenancy agreement. The negotiating lasted 2 years and finally they failed to make a new tenancy. The appellant advised the defendant to confirm his tenancy, repossess, and surrender his rental flat on or before 1 October 2011. Defendant retained vacant possession of the properties to plaintiff on October 31st at 2011. Roha SS Sdn Bhd appealed to the court in order to claim the double rental from the Weatherford M Sdn Bhd and Arno because they were holding over the property after the expiry of the previous tenancy. The High Court dismissed the appellant claim and allowed the respondent claim for a refund of the rent deposit. On appeal, the Court of Appeal held that the appellant can only claim double rent for the period from 1 October 2011 to 31st October 2011 after the notice to quit is issued. There are 2 issues of the case. The first issue is whether the defendant should pay the double rent based on the defendant's holding over action. The second issue is whether the defendant should be charged by the appellant if the tenant holds over after the expiry of the tenancy. The principle of the case is based on Section 28 4A of Civil Law Act 1956. 4A state that every tenant holding over after the determination of his tenancy shall be chargeable, at the option of his landlord, with double the amount of rent until possession is given up by him, or with double the value during the period of detention of the land or premise so detained, whether notice to that effect has been given or not. And that's all for my part. I will deliver the remaining part to the next presenter.
Case 2 Yong Hong Tong vs Xiu Sunhua. Yong Hong Tong has get into a tenancy agreement in Chinese with Xiu of the entire ground floor of premise No 61 Jalan Pasar Baru in Kuala Lumpur. So, Xiu Kim Chong, which is the father of Xiu, asked the Yong Hong Tong to pay $8,000 for the building's renovations and also for the permanent tenancies. So Yong agreed to pay the $8,000 and also another $150 for a renter's fee per month, and it was increased by sales to $200. After 8 years, the tenancy agreements have made. The landlord, which is sales, has handed a terminations to Yong, unless he accepts a new tenancy which is $300 per month. So Yong disagreed with it and appealed to the court. In this case, there are two issues of the case. The first one is whether the tenancy agreement was valid and enforceable, and is the respondent entitled to specific performance of the agreement. Due to the Sections 221 of National Land Code, the maximum terms of which any lease might be so granted shall be 99 years if it relates to the walls of the alien lands, and 30 years if it relates a part only. So, the tenancy agreement was valid. Due to the Sections 149 of the Law of Property Act, this act can allow it convert a tenancy grant for life into a tenancy for terms of 90 years. In the case of Inward v. Baker, even though there are no binding contract, but equity can arise out of expenditures of money. So, the right of occupations of the tenant would be enforced in equity. This is because the respondent, which is Yong, has already occupied and paid the rent on the ground floor since 1958 year. Then he also paid his landlord a total of $8,000. And the effect of the uncertain provisions in tenancy before the National Land Court 1965 can be considered as a void agreement, but after it, the after 1965 National Land Court, the tenancy should be permanent, permanent, and the agreement is considered as a good lease agreement. However, when getting into a tenancy agreements, the terms of duration should be clear and not uncertain, which can avoid a workable agreement. That's all from me. Thank you.
In the case 3, we will talk about V. Tiang Yap versus Chan Chan brothers. In this case, one V. Portin, the father of the applicant, claimed the vacant position of premise in Kota Baru from the respondent, alleging that they were trespasser. The respondent were previously the tenant of the premise, but the set of reporting that has issued notice to quit the respondent. The notice expiring in 1st of the March 1976, it subsequently appeared that reporting was no longer registered owner of the premise at the date of the filing of the writ, as he has transferred to its son. It was also agreed that the respondent had been paid the rent to reporting right up to August 1979. Before the judgment, reporting that and the applicant continued the action as representative of his estate. The land trial judge held that on the death of the temporary occupation landowner, his estate has no right of any kind of the land. He also held that Section 116 of the Evidence Ordinance cannot prevent the tenants from the contending that neither the decrease nor the window had any title to the land. The land judge therefore dismissed the claim and ordered that the sum of about 16,800 ringgit be paid to the respondent under the counterclaim. The issue of this case is the respondent is right to contend the applicant title is barred. The applicant was entitled to the double rent as the trespass damage since the defendant had knowing stayed on the property after the notification time has been passed. This judgment for this case is referred to Section 116 Evidence Act 1950. It has to do with the license and tenant estoppel of the person in possession. No tenant of real estate or person making claim during the term of the tenancy denying that the landlord of such tenant had, at the commencement of the terms. Other that is refer the Section 125 of National Land Code. Whenever a condition is broken, the condition that require continuous performance will be in branch as soon as it not meet and will continue to be violent as long as it is. And then is the Section 127 from Penal Code, receiving or trying to receive the property with knowledge that it was stolen in the commission of one of the crime lists in Section 125 and 126 in subject to a 7-year jail sentence, a fine, and confiscation of the property was received. This case also refer the Section 66 of the Contract Act. If an agreement is found to be invalid or of if a contract is declared invalid, the party who benefits from the agreement or contract must pay the other party restoration or compensation for their loss. And in this case, we can also refer the cases of Mok Dan Chi and versus Yap Si Hui. This case is about the landlord and the tenant. The house is belonging to another person. The ground rent paid to the owner of the land. The tenancy coupled with the equity, whether the notice to quit the valley. Whether the tenancy coupled with the equity can be determined by the bare notice to quit. For this case, we can see a tenant may rely on the encouragement of the landlord, spend his money to improve the land in the expectation of being remain on the land. When the landlord serves the tenant a notice to quit, the tenant may rely on the doctrine of tenancy coupled with equity and seek to set aside such notice. The remedy granted by the court will be landlord will be estoppel from terminating the tenancy until he has certified the tenant's equity or pay an amount to the tenant as compensation.
My name is Wong Hui Si, and now I will present about the case for Metamac Corporation Sdn Bhd versus Fazia Holdings Sdn Bhd 2007. The plaintiff is dissatisfied because it did not receive the funds it was legally due. The plaintiff should not have gotten anything, according to the defendant. Basically, the lawsuit is for a contract breach. The plaintiff's alternative claim, however, is that the express trust was broken. Aside from defending the action, the defendant filed a counterclaim claiming a number of declarations which will address at the appropriate point in this judgment. There are two issues being discussed in this court. Firstly, the appellant filed an appeal against the Court of Appeals ruling on October 25, 2005. Secondly, the corresponding request made by two individuals to have specific conclusions and remarks from two courts of appeal judgment thrown out in the grounds set forth in their individual activities. Next, the issue of the case. Firstly, whether a company violated the law by reducing its capital through the creation of a trust. Secondly, if Clause 8 of the Signet Agreement is a stipulation by way of a penalty or a sum named in the contract for purpose of Section 75 of the Contracts Act 1950 is the test used by the Court of Appeal the right one or exclusive. Thirdly, whether there is a genuine risk on the part of the Court of Appeal in the judgment rendered against the appellant in light of the Court of Appeal's unfavorable comments in the circumstances of this case when viewed objectively. Section 30 of the Contracts Act 1950. According to Section 30 of the Contract Act of 1950, a contract that cannot be made certain or is uncertain is void. Unambiguous factual statements that form the basis for an action are understood to be certainties. Next, Section 64 of the Companies Act 1965. This section is the special resolution for the reduction of share capital. A company may reduce its share capital in any manner subject to confirmation by the court if such a reduction is permitted by its articles of incorporation. Like Section 75 of the Contracts Act 1950, a clause in a contract that specifies the amount of damages to be paid, such as Section 75, allows for liquidated as certain damage. The party who breached the contract is still entitled to compensation that is reasonable and does not exceed the amount specified in the contract. That's all for me, then I will pass to the next person.
Good morning, I am Li Chiwei. Now, I will talk about the case of issue pertaining lease and tenant in Malaysia. This case is Wan Salimah Wan Jaafar vs. Mahmud Omar. In 1997, the plaintiff Wan Salimah Wan Jaafar sued the defendants Mahmud Omar in the High Court of Johor Bahru. The plaintiff have 3 land lease on defendants on Pulau Sipu for 15 years period with a written agreement. After they signed out the contract, the plaintiff paid 1,800 ringgit Malaysia, which is the annual rental of the land, to the defendants immediately, and the plaintiff's husband is the witness of entire process. Then the plaintiff built 2 homes on the land, but the defendant refused to sign Form 15A of National Land Code 1965, and caused the lease was not registered. After that, the defendant listed the property for sale and entered into a sales and purchase agreement with the intervenor, Anim Alub Aji. In court, the defendant claimed he was unable to read and write and made a defense of non-ex-fatums. However, the claim of non-ex-fatum was not successful because the plaintiff and the defendant have signed the agreement and the defendant knows it is a contract. The evidence also shows the defendant was conscious of why he signed the written agreement, hence the declaration was not accepted by the court. In the End of the case. Although it is a non-registered lease, but is still legally binding as an agreement for a lease. We have 4 issues in this case. The first issue is whether the defendant could raise the doctrine of non-ex factum. Second is enforceability of unregistered lease. The third is whether the intervenor was a bona fide purchase. The last is, will it be possible for the representative to testify in place of the intervenor? For just opinion, in sections 32B of Evidence Act 1950, it recognized the validity of a written agreement, even if there was not witness present to testify. So the court assumed the witness act in the regular course of business without a motive or interest. After that, in section 221 4 of the National Land Code 1965, it lays out every single lease that should be granted by Form 15A. The lease should include a plan and description sufficient to allow the plaintiff to identify the portion of alien land covered by the lease. In sections 206(3) of National Land Code 1965, the plaintiff should be given liberal interpretations when the parties carry out their statement in the contract. The contract will be valid. The lease agreement is as good as a lease. After that, in sections 3(1)(a) of Power of Attorney 1949, the representative of intervenor is not allowed to submit evidence because the power of attorney between them is not meet the requirements or they stay in the sections 3(1)(a) of Power of Attorney 1949. Thank you.
For present this slide, the conclusion for our report. The summary for case 1 is the action of holding over as an appealable case. Since both defendants refused to pay under Section 28 4A of the Civil Code Act 1956, hence, case 2 is protected by suitable as bottle. Then, according to Section 116 Evidence Act 1950 in case 3, tenancy have to pay no matter whether die or widow. Case 4. Section 64 of the Company Act 1905 is a special resolution of reduction of share capitals. Section 32B of the Evidence Act 1950 recognizes the validity of the written agreement even if there was not witness present to testify, which is the summary of case 5. In short, we are the suggestion about in any trend must be reminded no party in the contract is allowed to degrade or assign any obligation or right without prior written consent from the other parties. Any delegations or assignment in violation of these provisions should be deemed void. So that's all from our group presentations. Thank you for listening.